Here is your story. Marcus Webb wore a tie to court that was 2 sizes too small. His mother had knotted it for him at 6 in the morning, her hands shaking just enough that she had to try 3 times. She smoothed it against his chest when she finished, pressed her palm flat over his heart like she was trying to hold something in, and said, "You look good, baby." He did not look good. He looked like a 17-year-old boy wearing his uncle's tie. But he kept it on. The courtroom was on the 4th floor of the Allegheny County Courthouse, a room that smelled like old wood and older decisions. The ceiling was high. The lights were fluorescent. Every sound, a cough, a chair scraping, a briefcase clicking open, bounced off the walls and came back slightly wrong, like an echo that had lost confidence in itself. Marcus sat at the defendant's table and kept his hands flat on the surface in front of him. On his left was a stack of index cards, edges worn soft from handling. On his right was a yellow legal pad covered in his own handwriting, tight and small, the way you write when you are trying to fit everything important into a limited space. He was alone at that table. That had been his choice. 3 weeks earlier, his public defender had given him 11 minutes of her attention in a hallway outside a different courtroom. Her name was Sandra Cho and she was not a bad lawyer. She was a lawyer with 41 active cases who had spent the previous night reading about a completely different client. She had Marcus's file in one hand and her phone in the other, and she told him, in the efficient tone of someone delivering a weather forecast, that his best option was a plea deal. Community service. 60 hours. Clean record in 2 years if he stayed out of trouble. "I wasn't trespassing," Marcus said. She looked at him over the file. "I know you feel that way. I have proof." "Marcus." She said his name gently, which was somehow worse than if she had said it impatiently. "The security footage shows you in the building at 11:47 at night. The lock on the side entrance was cut. They have a timestamp. A judge looks at that and sees a break-in. The lock was already broken when I got there. I have a photo." She paused. "You have a photo? With a timestamp? And I have an email from my teacher giving me permission to be in the lab. And I have the server log showing I logged into the school system at 11:49 and submitted my project at 11:52. Sandra Cho lowered the file slightly. For the first time in 11 minutes, she looked at him like she was actually seeing him. Then her phone buzzed. She glanced at it. "Bring all of that to our next meeting," she said. "We'll talk." Their next meeting never happened. She rescheduled twice. The second time, she sent an assistant to tell him, and the assistant got his name wrong. Marcus fired her on a Tuesday. His mother did not take it well. She sat at the kitchen table with her hands wrapped around a mug of tea that had gone cold and stared at the wall while Marcus explained his reasoning. His grandmother, who was visiting from Pittsburgh and had strong opinions about everything, stood at the stove pretending to stir something and listening to every word. "You are 17 years old," his mother said. "I know. You are going into a courtroom. Against a prosecutor. By yourself. I know. Marcus." She turned to look at him. Her eyes were not angry. They were scared, which was harder to sit across from. "This is not a debate competition. This is your record. This is your life." "I know what it is," he said quietly. "That's why I'm not letting someone handle it who doesn't have time to care whether I win." His grandmother made a small sound from the stove. Not a word. Just a sound. The kind that meant she had heard something true and was acknowledging it without committing to an opinion. His mother looked at him for a long time. She did not say he was right. She did not say he was wrong. She picked up her cold tea, took a sip anyway, and said, "You better know what you're doing." He did not know what he was doing. But he was going to learn. The public library on Forbes Avenue had long tables near the back windows where the afternoon light came in at a low angle and turned everything golden and a little sleepy. Marcus claimed the same spot for 5 days in a row. He brought his backpack, his laptop, and a pack of highlighters in 4 colors, yellow for important rules, blue for exceptions, pink for cases he wanted to read more about, and orange for things he didn't understand yet. By day 3, most of the orange was gone. He read the federal rules of evidence cover to cover. He read a first-year law school primer on courtroom procedure that he found in the back corner of the legal section, its spine cracked and its margins filled with someone else's old notes. He read those notes too. He took his own notes. He made index cards for every rule he thought the prosecutor might try to use against him and every rule he thought he might be able to use back. He rehearsed in the bathroom mirror at home, which felt ridiculous and then felt necessary and then just felt like the thing he did each night before bed. The librarian, Mrs. Anita Okafor, noticed him on the second day. She was a small woman with reading glasses she wore on a beaded chain around her neck and a way of moving through the library like she owned every inch of it, which she essentially did. She did not ask him what he was working on. She did not offer advice. On the afternoon of day 2, she simply appeared at his table, set down a paper cup of coffee from the little machine near the circulation desk, and walked away. The coffee was bad. He drank all of it. She did the same thing on days 3, 4, and 5. On the last day, as he was packing up his bag, he said, "Thank you for the coffee." She looked at him over her glasses. "Come back and tell me how it goes," she said. And then she went back to shelving books. Philip Greer had been an assistant district attorney for 19 years. He was the kind of man who inspired confidence without doing anything particular to earn it in the moment. It came from the way he stood, the way he arranged his papers, the way he spoke in full sentences that felt like they had been professionally pressed, with no wrinkles. He had gone to Penn Law. He had won most of his cases. He kept a photo on his desk of his daughter at her high school graduation, and he mentioned her sometimes in conversations with colleagues in a way that was meant to say something about who he was. He looked at Marcus across the courtroom and felt something close to pity. A teenager with index cards. No lawyer. A misdemeanor case that should have been wrapped up in 45 minutes. He would be home by lunch. Judge Carl Dietrich had been on the bench for 22 years. He was not an unkind man. He was a man who had seen so many cases that they had begun to blur at the edges, which was its own kind of problem even if nobody talked about it that way. When Marcus stood and stated his name and told the court he would be representing himself, Dietrich looked at him the way you look at someone standing at the edge of something dangerous. "Son," he said, and the word itself contained a small universe of doubt, "do you understand that you have the right to an attorney? That one can be appointed for you if you cannot afford one." "Yes, Your Honor." "And you're choosing to proceed without representation?" "Yes, Your Honor." Dietrich looked at him for a moment. Then he looked at Greer. Then he looked back at Marcus. He took a breath that the whole room heard. "All right," he said. "Proceed." Greer's opening statement was clean and organized. He laid the facts out in order. Marcus Webb, age 17, was recorded on the school's security system entering the Westbrook High Computer Lab at 11:47 p.m. on the 14th of October. The side entrance lock had been cut. No one had authorized his presence on school grounds at that hour. The charge was criminal trespass. It took 12 minutes. It was convincing. It was supposed to be the whole story. Marcus stood up. He did not start with innocence. He did not say, "I didn't do it," or, "There's been a mistake." He had read enough to know that wasn't how this worked. You didn't argue with what the other side said. You made the other side's argument matter less than yours. He started with the email. On the afternoon of October 14th, he told the court, his computer science teacher, Ms. Delia Reyes, had sent him a message through the school's official communication platform giving him explicit permission to use the lab that night. He had a deadline for a regional coding competition. The submission window closed at midnight. The email said, and he read from it, "Lab access is fine tonight, just make sure you lock up after." He submitted the email as evidence. Greer objected. Hearsay. Marcus picked up an index card. Blue highlighter. He had known this was coming. "Your Honor," he said, "this email falls under the business records exception to the hearsay rule. Rule 803, subsection 6 of the Federal Rules of Evidence." The email was sent through the school district's official communication system, as part of the regular process of a school employee coordinating access to school resources. A school is an institution with regular administrative operations. This message is a record of one of those operations. He set the card down. "A school is a business, Your Honor. Administering students and managing school resources is its regular business activity." This email is a business record. The room was quiet. Dietrich looked at the index card. Then at Marcus. Then at Greer. Response, Counselor. Greer opened his mouth. Closed it. Said, the authentication of the document hasn't been established. Marcus was already reaching for another card. Yellow. Authentication. Rule 901 of the Federal Rules of Evidence, Your Honor. Authentication can be established through evidence sufficient to support a finding that the document is what the proponent claims. I can provide the email headers showing the sender address, the school district domain, and the timestamp. I can provide the school's own IT records showing the email was transmitted through their internal server. Both are available in the exhibits I've prepared. He lifted a thin folder and held it up. I have copies for the court and for the prosecution. It took Greer 3 more objections to understand that this was not going the way he had expected. Each time he raised a challenge, Marcus went to his index cards. Not frantically, not searching, but directly, like a person going to a specific drawer in a familiar kitchen. He knew where everything was. He had put it there himself. The school's server log showed Marcus had logged into the system at 11:49 p.m. His project submission timestamp read 11:52. He had been exactly where he said he was, doing exactly what he said he was doing, with exactly the permission he said he had. The photograph of the lock came in last. Marcus had taken it when he arrived at night and noticed the lock lying broken on the ground near the entrance. He had taken it on his phone out of simple caution, the kind of caution that comes from being a young black man who has been taught his entire life that the margin for error available to him is smaller than the one available to other people. He had not known he would need it. He had taken it anyway. The timestamp placed it at 11:44 p.m. 3 minutes before the security camera caught him entering. He did not cut the lock. He found it cut. He documented it. He went inside to do his work. He left. That was the whole story. Greer was quiet for a moment after the photograph was admitted. He looked at his papers. He looked at Marcus. He looked at his papers again. He said, Your Honor, I'd like a brief recess. Dietrich granted it. In the hallway, Marcus sat on a wooden bench and ate half a granola bar from his backpack and tried to slow his heartbeat down to something a normal human being would have. His hands were not shaking. He was surprised to discover this. He looked at them as if checking someone else's hands. His mother was sitting 3 rows back in the courtroom. He had told her not to come. She had looked at him with the expression she used when she was not going to argue but was also not going to listen, and she had been in the front row of the public gallery when he walked in. She had moved to the 3rd row sometime after his first exchange with Greer, which he took to mean she was trying to look like she was not with him in case things went badly. He ate the rest of the granola bar. When the session resumed, Greer argued for 10 more minutes. The arguments were smaller now. Narrower. The kind of arguments you make when the large ones are gone. Marcus responded to each one. He was not sharp or aggressive. He did not perform outrage or triumph. He was simply prepared, which turned out to be its own kind of devastation in a room where nobody had expected preparation. At one point Dietrich asked Marcus to clarify something about the server log's admissibility under the business records exception, and Marcus answered the question in 2 sentences, cleanly and correctly. Dietrich made a note. Greer gathered his papers for the last time. The judge took 11 minutes to review everything that had been entered into evidence. The courtroom sat in the specific silence of a room waiting for something it has already begun to understand. Dietrich looked up. The court finds that the evidence presented by the defendant establishes, clearly and convincingly, that the defendant had authorization to be on the premises on the night in question, that the lock in question was already compromised prior to his arrival, and that his presence and activities were consistent with that authorization. He paused. The charge of criminal trespass is dismissed. He set down his pen. Case closed. Greer was already packing when Marcus turned around. His mother had both hands over her mouth. When he reached her, she wrapped both arms around him and held on with the grip of someone who has been frightened for a long time and is trying to convince themselves it is over. He let her. He stood there in the too-tight tie and let her hold on. His grandmother called that evening and said, "I told you," even though she had not told him anything. He did not point this out. Before Marcus left the courtroom, Judge Dietrich spoke from the bench. Marcus had his bag over his shoulder and his index cards gathered back into a stack. He was already thinking about the bus schedule, about calling Mrs. Okafor, about whether he had time to eat a real meal before his shift at the grocery store started at 4. Dietrich said, "Young man." Marcus turned. The judge looked at him for a moment. Something moved across his face. Not an apology. Not quite a compliment. Something more complicated than both, the look of a man recalibrating something he had believed without knowing he believed it. "Good work," Dietrich said. 2 words. Plain ones. The kind that cost something to say and something to hear. Marcus nodded once. He walked out. The library was open until 8. Marcus was there by 3:30. He took his usual table near the back window. The afternoon light came in low and golden, the same as always. He opened his backpack and pulled out a new book, a first-year contracts textbook he had ordered online for $6 plus shipping, its cover creased from a previous owner's use. He opened it to the first page. Mrs. Okafor appeared at the table without him hearing her approach, which was something she seemed to do on purpose. She set down a paper cup of bad coffee and looked at him over her glasses. "How did it go?" she asked. "Dismissed," he said. She nodded once, as if this was exactly what she had expected and not at all a surprise. Then she turned and walked back toward the circulation desk, her shoes quiet on the library floor. Marcus looked at the coffee. Then at the book. He highlighted the first important sentence in yellow. Behind him, somewhere in the stacks, Mrs. Okafor began shelving books in the calm and certain way of someone who has always known that the most important work happens before anyone is watching. The tie was still too tight. Marcus didn't fix it. He never needed to.